the quorum call.
Ask unanimous consent to quorum call be dispensed with and be allowed to speak as if in morning business.
Without objection.
Mr. President, I want to rise in opposition to the second Feinstein amendment, which is number 1126, I believe. I have the privilege of serving as Vice Chairman on the Intelligence Committee with Chairman Feinstein, and we have a very good working relationship, agree on most every issue that comes before the committee. And I know the diligence and seriousness with which she takes every issue, but particularly this issue, because we've had a number of discussions about the fact that we have a lack of a detainee and interrogation policy in this country now. And I know she's concerned about that, and I know she's trying to make the situation better. And I remain committed to work with her on a solution. Unfortunately, I'm going to have to oppose her amendment today because of my concerns about the limitation it imposes on the authority to detain Americans who have chosen to wage war against America. My first concern is that it appears from the debate yesterday that there is confusion among some members about what this amendment does. For example, my colleague and friend from Illinois, Senator Kirk, argued that he is in favor of robust and flexible U.S. military action overseas, including against American citizens like Anwar al-Awlaki. Senator Kirk said he supports the Feinstein Amendment, however, because he believes in a zone of protection for citizens inside the United States. But the Feinstein Amendment does not apply to only those American citizens who commit belligerent acts inside the United States. It would also prohibit the long-term military detention of American terrorists like Anwar al-Awlaki who commit terrorist acts outside the United States. As a result, this amendment would have the perverse effect of allowing American belligerents overseas to be targeted in lethal strikes but not held in U.S. military detention until the end of hostilities. That just makes no sense whatsoever. I'm also concerned about the ambiguity in the amendment's language and the uncertainty it will cause for our operators, especially our operators overseas. The amendment exempts American citizens from detention without trial until the end of hostilities. But short of the end of hostilities, the amendment appears to allow detention without trial. Is the Senator's intent to allow for some long-term detention of Americans without trial? This ambiguity is troubling because we don't know how the prohibition will be interpreted by our operators or by the courts that will hear inevitable habeas challenges. Would the military be permitted to hold a captured American belligerent for a month, a few months, or a few years, as long as it was not until the end of hostilities? Or would the military interpret the amendment as a blanket prohibition against military detention of Americans for any period of time? If the military rounded up American terrorists like Adam Gaddam or Adnan Shukri Juma among a group of terrorists, would they have to let these Americans go because the military would not be permitted to detain them? And would more American belligerents be killed in strikes if capture and detain operations were perceived to be unlawful? I just don't believe we can leave our operators with this kind of uncertainty. Finally, we should all remember that the provisions in the National Defense Authorization Act do not provide for a new authority to hold U.S. citizens in military detention. American citizens can be held in military detention under current law. And contrary to some claims that were made yesterday in debate on this floor, these Americans would be given ample due process to their ability to bring habeas corpus challenges to their detention in federal court. The Supreme Court has held in the Amdt case that the detention of enemy combatants without the prospect of criminal charges or trial until the end of hostilities is proper under the AUMF and the Constitution. Amdt is a U.S. citizen. This is not a new concept. In reaching its decision, the Amdt Court cited the World War II case Ex parte Quirin, in which the Supreme Court held, and I quote, Citizenship in the United States as an enemy belligerent does not relieve him from the consequences of a belligerency. In conclusion, I understand Senator Feinstein's motivation, but I just don't believe this amendment does what she wants it to do, and that there will be unintended consequences that could seriously hamper overseas capture operations. Mr. President, I urge my colleagues to oppose the Feinstein amendment. And I yield the floor.
Mr. President.
Senator from Iowa.
To speak in morning unanimous consent